Now, before addressing cooperation, which has been already rather exhaustively addressed by Mirela, I would like to step back a little bit and to make a couple of general remarks. The first, which is precisely about the welfare of children. We all know that the best interests of the child are the cornerstone of Brussels IIa. Now, I think if we are serious about the interest of the child, we have to focus our attention not just on resolving disputes once they arise, but also on preventing those disputes in the first place, or preventing the escalation of those disputes. And this is something that I would like to stress because we tend to overlook it. The best interest of the child is a multi-dimensional notion. There's a lot of components in it. I think we all agree that the interests of the child are generally best preserved if his or her parents live in harmony with each other. That's first layer, first dimension. Should the parents decide to separate, which they're of course free to do, the interests of the child are best satisfied if they manage to break up without tearing each other apart and without tearing the child apart. I'll soon become the father of a little boy. He's due in March 2021. And so should my wife and I decide to separate at some point, that's not on the agenda, but you never know, this would be harsh for him. And what we hopefully would want to avoid is to add suffering to harshness and have him caught up in a long battle between us that would leave the three of us drained physically, emotionally, and financially. So there seems to be little mention among lawyers who speak about child best interests all the time, about the adverse impact of a prolonged litigation on children as well as on parents. Sociological and medical studies show that a child that has to endure a high intensity conflict between parents is 2 to 3 times more likely to underperform at school and fall behind, to experience depression, as well as several other psychological disorders, to display suicidal tendencies, to develop inclinations to violence, to struggle to find a good job, and to end up being dependent on public money. Now, bearing this in mind, if we turn to the cases that were brought to the Court of Justice concerning Brussels IIa, and we contrast those cases with the best interest of the child, I think the picture is rather gloomy. On average, if we read carefully those decisions, as many as 15 procedures were inflicted on those children, with some of them being at the center of as many as 35 procedures, and the dispute was not settled after 12 years. Mercredi, Povse, Renau, Puruker, Campanella, Liberato, these are flesh and bone children. Those battles were fought most of the time in 2 countries, 2 sets of expensive proceedings whose combined outcome was oftentimes a deadlock. Each of the 2 countries having their own recipe on how best to take care of a child who's in fact belongs to 2 state communities. If you scratch a little bit the surface of the factual history underlying the ECJ rulings on Brussels IIa, you realize that the disagreement was not just between the parents, but between the 2 member states, between England and France in Mercredi, between Italy and Austria in Povse, between Spain and Germany in Puruker, between Italy and Latvia in what was the name, in Stersno and Campanella. Now, I think it would be interesting to interview some of those kids and some of those parents. Why don't we invite them to testify? Zoom offers expanded opportunities to hear from the human beings what the impact of rules has been on their lives and what they have to say about how to improve the system. I'm proud to say my team interviewed some of them. I have become a friend of Isabel Neulinger, who was involved in one of the most notorious abduction cases. We interviewed Doris Pozze, who said she spent 200,000 euros in legal fees. As we discussed with Ilaria a couple of days ago, this is money that the parents could not spend on the education of their child. The child, Sofia, had to undergo a long psychiatric treatment. Another case, for 12 years, the son of Stefano Liberato and Luminita Grigorescu could not visit with his father in Italy. So I think, paradoxical as it may sound, those ECJ cases are the best example of what we should try to avoid. What little Sofia Povze, Marco Campanella, Andrea Porrucker had to endure, I think, is diametrically opposed to virtually all notions of their welfare. So I think we should pay more attention to prevention of conflicts or conflict escalation. In fact, Brussels IIa does care about prevention. The section about child abduction is primarily designed to deter abductions, which was repeatedly emphasized during the revision process. Agreements between parents are favored by the recast. Mediation is also strengthened. Stefan Auerbach, who's an experienced mediator, may talk about this later on. The trouble with mediation is that it is too often triggered too late. And so I think we had to act in advance. This may be done in a lot of different ways. In Denmark, for example, empathy classes are taught in school. Empathy being the ability to look at the reality with the eyes and under the personal circumstances of other people. Something we may also think about is to offer some tutorials to parents at the time when they become parents. Public education campaign, for example, before birth. My wife and I have two classes scheduled in January, almost compulsory classes, on how to handle our baby. I'm feeling a little under pressure, I have to say. So why shouldn't child protection agencies offer parents some additional training about the likely impact for their kids flowing from a parental fight? We may call for testimonials. We may ask Isabel Neulinger to recount her experience and her ordeal. So there is some food for thoughts for us and for the European Parliament. The second thing I would like to say is that it is commonly believed public international law has little in common with private international law. Now, public international law is precisely about cooperation between states. And Brussels IIa creates a whole bunch of rights and obligations between states and their authorities to make sure rights and obligations between private persons, children, and parents exist and are effective. So the regulation is both public and private international law. And by the way, the public side of things and the private side of things tend to be inextricably linked when it comes to children welfare. Now, I would like to move to cooperation, although a lot of things have already been covered by Mirela, which simplifies my task. In broad terms, the whole Brussels IIa is about judicial cooperation. That's the heading of Title 5 of Chapter 3 of the TFEU. So I think today, as Mirela did, we had to embrace a narrower definition of cooperation. I'll start with Mirela having provided the legal framework. And I think I can start with some of the shortcomings listed by the Commission. The proposal says the recast, quote, clarifies who can ask which assistance or information, from whom and under which conditions. The first difficulty encountered in practice is apparently about locating the child's whereabouts. This has been already mentioned by Mirela. I would like to take a case study. I am going to imagine a mother who is Portuguese and French, dual national, who has family in Portugal and in France. She wants to escape what, in her views, amount to domestic violence from the Spanish father. So she leaves her Spanish home and takes her child with her. She does not mention where she goes. She wants to hide from her husband. And so, based on the recast, her husband is entitled to request the Spanish Central Authority that they contact the Portuguese Central Authority and the French Central Authority in order to know where the child is Portugal, or the child is in France. A similar provision exists in the maintenance regulation. So locating the child whereabouts is a precondition for the father, in my hypothetical, to initiate return proceedings. What the recast also specifies is that not only the father, but also the Spanish Child Welfare Agency is entitled to make such a request. The recast, in fact, uses the term competent authorities to designate not only the judicial authorities, not only the central authorities, but also the child protection authorities. What the drafters back in 2000 seem to have a little bit overlooked is the pivotal role that those mostly administrative agencies in fact play when it comes to parental responsibility. The 2014 study by the Commission further says that, I quote, experts have reported difficulties in connection with the obligation to collect and exchange information on the situation of the child. So what now Article 80, according to the new numbering, mentions is report, not just to provide information, to produce a report. A report is a potentially detailed child's assessment or home assessment, however we may want to call it. So the work, as Mirela said, the work the central authorities are expected to do is of greater magnitude and of greater responsibility. That's why the recast requires member states to make sure those authorities are adequately funded and appropriately staffed. I will try to follow up on my hypothetical. I will assume that mother had moved to Portugal rather than to France, and so the child turns out to be in Portugal. The recast clarifies that the Spanish authorities of the habitual residence of the child may request the central authority in Portugal to produce a full report on the situation of the child in Portugal. Obviously, the Portuguese central authority may instruct a local child protection authority to do the job. This is what mostly happens according to my experience. The recast further indicates that the request has to be completed by a translation into the language of the requested state. Importantly, there's also a specific time limit to minimize delays, a specific time limit to produce the reports, 3 months. Another critical issue is visitation rights. I would like to spend a couple of minutes about this. If you're a parent and you don't get custody, you expect at least to get visitation. I'm going to imagine a French/German case, mother French, father German, habitual residence of the child is Germany, close to the French border. After breaking up with the father, the mother moves to nearby France, Strasbourg. She wants the child to relocate with her to France. The German authorities have jurisdiction altogether as a whole. The Jugendamt, the child protection authority in Germany, will, I guess, have to prepare a report for the German courts. As we've seen, the Jugendamt will be entitled to request a report from the French central authorities on the mother's situation in France. What kind of flat does she live in? What kind of job does she do? What kind of assistance would she be able to get from her family if she is awarded custody? I guess the French central authority in Paris will instruct a local child protection authority in Strasbourg to conduct this inquiry. And so we will have the child protection agencies of the two countries involved, Germany and France, that work separately, not together, in parallel on child assessment, which I think is a good thing. I'm going to assume the Jugendamt will recommend the German court awards custody to the German father, notwithstanding whatever the French report says about the mother aptness to look after the child in France. Apparently, the Jugendämter tend to favor the German parents. Big problem. They have been accused to believe the best interest of a child who's half German is almost systematically to live in Germany. A number of hearings, and I was present at a number of those hearings in the petition committee of the European Parliament, were held to discuss these serious allegations. Back to our scenario, I will assume German courts award visitation rights to the mother, so custody to the father, visitation rights to the mother. The mother is twice a month allowed to take the child to France. But there is an important but, because based on German practice, the custodian parent does not seem to be under a lot of pressure to make sure visitation rights of their fellow parent are effective. Now, what the recast specifies is that the French mother may request the French judicial authorities to specifically request cooperation from the German court to make sure the father cooperates with the mother. It's a long chain. The father cooperates with the mother with implementing visitation rights of the mother. Now, I personally am not sure that the problem will be solved, because apparently under German law, if the custodian parent, that's the problem with German law, if the custodian parent refuses to allow visitation, this is mostly without consequence, especially if the parent holding visitation rights fails to pay maintenance. There's a kind of droit de rétention. Under French law, the situation is different. Under French law, failure by the custodian parent to hand in the child for visitation may be a criminal offense. I've seen French mothers convicted to up to 6 months imprisonment avec sursis, suspended sentence, for preventing the father to see the child as agreed before a court or as prescribed by a court. Which brings me to the difficulty. I think I still have a couple of more minutes. This brings me to the difficulty of defining when there is cooperation and when there is lack of cooperation. That's an important point, I think. A good illustration is transfer of jurisdiction to a better placed court. Article 15 now, Article 12, according to the new numbering. If you think back to the facts in Povze, the Austrian judge had requested the Italian judge to transfer jurisdiction to Austria. The reason was pretty clear to me. The Austrian judge wanted to award custody to Mrs. Povze, the Austrian mother, and allow Sofia to remain in Austria, which is part of the reason why the Italian judge, who wanted the child to grow up in Italy with the Italian father, refused to transfer jurisdiction to Austria. Now, is this an example of cooperation between judges? Or is this an example of lack of cooperation between judges? I think in Povze, and the same is true to about many other cases that were brought before the European Court of Justice, Austrian and Italian courts had different views on whether Sofia, who's both Italian and Austrian, should be raised in Italy with Italian father or Austria with the Austrian mother. Which brings me to my final point. I think 20 years from now, maybe earlier, it depends on us, maybe earlier, people in the situation of Povze and Alpago will be allowed to rely on a European tribunal, one where an Austrian judge will sit side by side with an Italian judge. And the two judges will have to cooperate, not as single state judges, but as part of the same multinational panel. And for example, a Croatian judge will be presiding over such a multinational panel. A president should not be Austrian, should not be Italian, something in between, Croatia. And I think, for example, Martina Drentic, who helped organize this conference, will be perfect for the job. By that time, she will have not just the required legal knowledge, but perhaps more importantly, the required wisdom, experience in life, and sensitivity. So multinational judges to adjudicate disputes on multinational families, European tribunals to adjudicate disputes between members of European, binational, or multinational families, which is fair to the child, to both parents, to both member states. I have written some papers on this. You'll find them on the repository of my university. Many thanks for everybody for listening.